D.C. appeals court ruling no one's above the law and rejecting those immunity claims we've heard so much about. The judges, as I told you at the top of the hour, said that the key thing, if you remember nothing else, is that we're now dealing with citizen Trump, not President Trump. Trump appearing in court last month and witnessed that contentious hearing with some of the sound we also played you and that ricocheted around the world, quite frankly. A former president running for office again, talking up the idea that he could have people killed and never be held accountable for it, that he could literally kill his American political opponents. And they said that if you accepted that, though, that if Trump got that kind of immunity, well, wouldn't that open the proverbial Pandora's box?
To authorize the prosecution of a president for his official acts would open a Pandora's box from which this nation may never recover. Could George W. Bush be prosecuted for obstruction of an official proceeding for allegedly giving false information to Congress to induce the nation to go to war in Iraq under false pretenses? Could President Obama be potentially charged with murder for allegedly authorizing drone strikes targeting U.S. citizens located abroad?
That voice you hear there was Trump's lawyer making some of his better arguments, not the, oh, can't the president kill Americans thing, but doesn't the president kill people and order them killed all the time? And do they have to worry behind their back that every one of those could turn into a later murder case? There is something to that argument. That's why, if you follow the news, you probably know sitting presidents, first of all, can't be indicted for anything at all, period. And second, there are great protections in the national security arena and otherwise. This is not, of course, the case about what the Army did or didn't do. Now, today, the judges said the interest in criminal accountability outweighs those so-called risks chilling presidential actions. Now, this is a very unusual thing that we're living through tonight, and it's because of how Donald Trump has acted, how he's rolled, how he's moved, that we have now an appeals court answering this question and making new precedent that reinforces a traditional concept. Because no other former president was ever indicted. Nixon worried about it but took the pardon. The judges use that law and history on their side because we have a lot of history to draw on. Now, let's take a non-criminal example, but the appeals court looked to something that has long been a benchmark for presidential power, a ruling that goes back to Truman, when in 1952 the Supreme Court did find a sitting president exceeded his authority. He tried to basically seize the steel mills. And here we see that, like Truman, this indictment charges that Trump violated laws enacted by the Congress. He exercised power at the lowest ebb, which is what you see on the bottom there. The Truman-Youngstown case discusses that presidential power is not static. Sometimes it's very high, like going to war, and sometimes it's very low, like without any other support from Congress or any other part of government, just trying to take, in that case, what was basically private property. The judges say Trump lacked the lawful discretionary authority to defy criminal law. He's answerable in criminal court for the conduct. And the ruling notes there's this recent historical evidence that former presidents, including Trump, have not believed themselves to be wholly immune from criminal liability. Now, in the previous segment, we were talking to legal experts who noted how respectful this is. That was a very respectful way to put it. But what they're referring to is, hey, you guys, the Trump lawyers, are full of it. Because you guys and gals, the Trump lawyers, recently said that, of course, Trump could be tried and prosecuted once he left office. So you are, they didn't say it this way, but you, the Trump lawyers, are lying. You're lying about the state of the law, and you're lying about your own positions. Now, we will say, when we use those words that are that strong, stronger even, I should note, than the court, we're going to show you exactly the evidence. Because look at the history of, say, Andrew Johnson, Richard Nixon, Bill Clinton, Donald Trump. They all faced a type of impeachment. No one was ever convicted. The judges pointed specifically to the Nixon example, who, of course, got that pardon from Ford. And they describe how the full pardon came in because those two people, both of whom had been president, Ford still was president, they knew and accepted as the obvious fact that a former president could be tried, charged, convicted. So that was needed. Take the pardon to avoid the legal fact that he could be charged.
It is common knowledge that serious allegations and accusations hang like a sword over our former president's head. I deeply believe in equal justice for all Americans, whatever their station or former station. By these presents do grant a full, free, and absolute pardon unto Richard Nixon.
That full pardon was to deal with the sword, as then President Ford put it. The point tonight is not whether you agree with that or not. The point is that it was such common knowledge in and outside of law that the sword of potential prosecution hung over Richard Nixon, that the pardon was their decision about saving him from that. Compare that to today, where, until today, Trump's lawyers were trying to make this argument that you could never do that, that that wasn't legally allowed. Now, Ford's decision proved very unpopular. He was the first incumbent president to lose since '32. Clinton agreed to suspend his law license and took a fine in exchange for a deal with independent counsel Robert Ray's non-prosecution agreement. The point here is not whether you think that the impeachment process and the perjury charges or any of that meant much legally. The point is that they negotiated with the DOJ because the DOJ was taking the position then that after leaving office, they could charge a former president. And the judges today also discussed that Trump knew well about all of this, that on the Senate floor, in public, as I mentioned earlier, the reason why I called this a lie is that his own lawyers very recently said, of course, he can be prosecuted once he leaves office.
After he's out of office, you go and arrest him. So there is no opportunity where the President of the United States can run rampant in January, the end of his term, and just go away scot-free. The Department of Justice does know what to do with such people.
True. That was a statement of both the ruling now today and Jack Smith's position at DOJ about why they could put Trump on trial. That statement just happened to be given there on the Senate floor very recently in 21 by Trump's own lawyer. When the court mentioned that today, that was a peak or a signal that they do understand just how extreme the Trump argument is to even be discussing all this in page after page after page. Because you can go back to Nixon, or you can go back to George Washington, or you can go back to the Constitution, which says that formerly impeached officials, once they leave office, can be tried like anyone else.